Hi, I'm Emily, and I am here with Maya Murphy's attorney, H. Daniel Murphy. Attorney Murphy practices at Maya Murphy's law offices in both Connecticut and New York. My question today for Attorney Murphy is, once I start a divorce action, who decides how bills are paid?
So once a divorce action is started, that means once a party is served with a summons and complaint to start the case, there's something called automatic orders, and the automatic orders apply from that point forward. So the automatic orders are orders that effectively go into existence as soon as the case starts, and those orders have to be followed and cannot be violated. Those orders essentially say that the status quo remains. Now, some of those orders relate to custody. For example, neither party is allowed to remove the minor children from the state of Connecticut without written consent. Or if the parents live apart, the orders say that the children are directed, or the parties are directed to facilitate communication between the children and both parents that's consistent with the habits of the family at that time. But there are also financial orders, and those are ones that are most often misunderstood or questioned. Those orders say that neither party shall sell, transfer, exchange, assign, remove, or in any way dispose of any property without the other party's consent in writing, except in the usual course of business or for customary and usual household expenses or reasonable attorney's fees. For example, you can buy or sell securities in the ordinary course of business if that's what you've been doing prior to the divorce action, as long as the funds remain within the same investment account or something similar, as long as you maintain or preserve the value of the estate. But you may not change the title of any asset. So you can't close a bank account, change the bank account from one party's name to another, or do the same thing with a vehicle, a house, investment property. And you're not allowed to encumber any property. That means you can't take any new loans or a home equity line of credit or incur any kind of unreasonable debts, excessive borrowing, cash advances, new credit card debts, anything like that. Essentially, the status quo is supposed to remain, and that means that income should continue to go where it had been going prior to the divorce action, and bills should be paid in the customary and ordinary household way. That goes for basic household expenses, like the bills that you asked about, even those not specifically referenced in the automatic orders. So, and also, neither party shall change the beneficiaries of any life insurance policies, and they have to maintain life insurance, automobile insurance, and those types of bills, homeowners insurance, renters insurance. They have to remain in full force and effect. So the automatic orders do touch those, although there are other things that fall within the umbrella of the order that aren't specifically referenced. So a failure by one party to continue to pay bills in the way that they were previously paid could result in motion practice, a motion for contempt and additional court orders. And a court would have the power to issue sanctions in that regard. And the sanctions could be anything from compelling a party to pay certain expenses to awarding attorney's fees for having to prosecute a motion like that. And there's also the possibility of what we call pendente lite motions, and those are temporary orders that one party is seeking for either temporary child support or temporary alimony, or motions for contribution to household expenses. That is asking the other party to be ordered to continue to pay bills that were being paid prior to the divorce and maybe have fallen by the wayside or are not being addressed while the motion is pending. So these kinds of motions take time, and they cost money, obviously, and they cost attorney's fees. And ordinarily, even with lawyers involved, it is best to find a way to craft an agreement that makes some sense for the parties. So generally, you should remember that once a divorce action starts in Connecticut, from a financial perspective, certainly things should remain as close to the way they were prior to the action being filed as possible. And if you need to do something differently, then you either need to have a written agreement or a court order related to those household expenses or those bills. In all cases like this, if you have any concerns about the automatic orders or about some interim bills that are either not being paid or not being addressed in some fashion, you should certainly speak confidentially with an attorney that either protecting or advancing your rights in that regard.